Each year, around 120,000 people are detained in New York City. They're read the following sentences by law enforcement. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. You may have heard of these following sentences before. They are called the Miranda rights. You may have seen them in movies and TV shows, but many people don't know that this all came from one court case in the year 1966 called Miranda v. Arizona. This court case changed the responsibilities of police officers and have changed the rights of the detained ever since the ruling of that case.
Prior to Miranda v. Arizona, or even your Fifth Amendment rights, confessions of the accused needed to be voluntary, making self-incriminations harder. This also created more difficulty for the court to decide if those confessions were true, depending on the accused and the questioner. This amendment relates back to the Magna Carta from when Britain still ruled over the American colonies. The Magna Carta was an important document for British citizens because it stated rules that everyone had to follow, even the king. Colonists also believed that they should have the same rights as British citizens. The Founding Fathers even used some of the rights from the Magna Carta as inspiration for the Constitution and Bill of Rights. For example, Clause 39 of the Magna Carta states that no free man shall be seized or imprisoned or stripped away of his rights or possessions, or outlawed or exiled or deprived of his standing in any way, nor we will proceed with force against him, or send others to do so, except by the lawful judgment of his equals, or by the law of the land, except by the lawful judgment of his equals, or by the law of the land. This clause influenced the Fifth Amendment since they were similar, as they both protected the right of the accused. Ernesto Miranda's history. Miranda's mom died when Miranda was at a young age, and his father quickly remarried. In 8th grade, he was convicted of burglary and had to undergo a year at Arizona State Industrial School for Boys. After getting out of reform school, he quickly brought up a record of crimes. It was March 3rd, 1963, and Lois Ann Jameson was walking back home from a long day of work from her job at a movie theater when she was approached by a Mexican man who was then later found to be Ernesto Miranda. Ernesto forced Jameson into his car, drove into the desert, and raped her. A week passed, and Jameson's cousin reported to the police that they found a suspected vehicle that Ernesto used to kidnap Lois. After the report, Phoenix police went to confront Ernesto, and he voluntarily went with the officers to go to the police station. At the station, Miranda was put into a lineup for Jameson to identify who raped her. In the end, she could not decide who the person was. Even though Jameson could not identify the kidnapper/raper, the police still interrogated Miranda for his history of crimes. They knew that Miranda couldn't speak English, and they still interrogated him. Ernesto was taken to 2 whole hours of interrogation, where he confessed to the crime. He also signed a statement that proved that his confession was made voluntarily.
Miranda stated that since he was never told his Fifth Amendment rights, the confession shouldn't count. The objection he made was overruled, and Ernesto Miranda was sentenced to 20 to 30 years in prison for rape and kidnapping. Shortly after this, the American Civil Liberties Union came in and asked 2 criminal defense lawyers to represent Miranda. The names of these lawyers are John J. Flynn and his partner, John P. Frank. Once Frank and Flynn agreed to take the case, they wrote a 2,500-word petition for certiorari. This means that they want a judicial review about their case. This petition argued that Ernesto's Fifth Amendment rights were violated since he was not told them. Finally, on November 15, 1965, the U.S. Supreme Court agreed to hear Miranda's case, creating the court case Miranda v. Arizona. The Miranda v. Arizona court case was more than just about Ernesto Miranda's case. It actually consisted of 4 different court cases that all had to do with self-incrimination. The 4 court cases involved was Miranda v. Arizona, of course, Fignera v. New York, Westover v. United States, and California v. Stewart. The year was June 13th, 1966, and the United States Supreme Court had published their opinion on Miranda v. Arizona. The court held that the prosecution may not use statements. This means that in a trial, the opposing side in court cannot use certain statements made by the defendant. The court held that the prosecution may not use statements, whether exculpatory or inculpatory, stemming from custodial interrogation of the defendant unless it demonstrates the use of procedural safeguards effective to secure the privilege against self-incrimination. By custodial interrogation, we mean questioning initiated by law enforcement officers after a person has been taken into custody or otherwise deprived of his freedom of action in any significant way.
The confession was overturned, and overturning the confession only resulted in another trial. This trial was set for October 24th, 1966, but Lois Ann Jamison, the victim, was expecting a baby. The trial was then postponed to February 15, 1967. John Flynn, who had originally argued for Miranda's case, was his lawyer for this case, and Robert Corbin would represent the state. Without the confessions as evidence, the case was bound to end up in Miranda's favor, as Jamison's testimony was doubtful. This all changed when Twyla Hoffman, Ernesto Miranda's wife, showed up in Corbin's office. She told Corbin that when Miranda was in prison, she had met another man and she had a baby. After she told Miranda, Miranda sent a letter to Arizona welfare authorities saying that Hoffman was unfit to be a mother and that Miranda should receive custody when he's released. After this, Hoffman met up with Miranda and visited him in jail. Hoffman stated that Miranda confessed that he was guilty of raping Jamison. Corbin convinced the judge that the story could be used as evidence, and it worked. Miranda was quickly found guilty of rape and kidnapping. He had to serve 20 to 30 years in Arizona State Penitentiary. Flynn, who did not believe Hoffman's story, tried to begin a round of appeals to the Arizona Supreme Court, but he got rejected. Then he decided to ask U.S. Supreme Court for an appeal. Unfortunately, the judges changed from 1966 to 1969. Earl Warren and Abe Fortas, who were important judges in Miranda v. Arizona, resigned. This meant that the second appeal for Miranda v. Arizona was shut down. Miranda, who was downcast from the refusal, became a model prisoner and was even released at 32 years old in December 1972. He worked from one job to another, and he even sold autographed Miranda cards for $2 each. In July 1974, he was driving on the wrong side of the road and went back to prison for a parole violation. He was eventually released on April 28, 1975, and stayed out of trouble. On January 31st, 1976, he was playing cards at a bar called La Amapola and accused one player of cheating when he was stabbed twice, once in the abdomen and once in the chest. He was rushed to Good Samaritan Hospital, the same hospital Lois Ann Jamison went after Miranda raped her, where they tried to keep him alive, but he unfortunately did not make it.
Miranda v. Arizona is a landmark case that changes how police work occurs in the U.S. This court case made it so police members couldn't trick victims into confessing into a crime they did or didn't do. Now police members have to tell the accused their Fifth Amendment rights every time they're stopped, and they also have to gather real evidence if they want to accuse the guilty individuals instead of tricking and landing an innocent person into prison. This court case is extremely important in giving the accused rights in court. This may be one of the most crucial and influential cases in criminal law.